Hello, my name is Maya Zahn Ryan. I'm an attorney in our real estate group at Reinhardt. I work out of the Madison office. I do a lot of acquisitions and sales of real estate and a lot of leasing work. I also have a subspecialty in oil, mineral, and gas law. Prior to coming to Reinhardt, I worked in southern Indiana where I did primarily coal and oil leasing. Today, however, I'm going to talk to you guys about recent changes to Wisconsin landlord-tenant law in Wisconsin. I will cover some topics like how landlords can deal with personal property after eviction, some of the security deposit rule changes, carpet cleaning rule changes, how landlords can terminate leases due to criminal activity, notices for non-rent breaches, limitations on local government authority, the new trespassing, at least property rules, and then I will also cover what I like to call the 10 deadly sins of residential leases. Those are 10 things that you absolutely cannot have in a lease. Having those provisions in a lease will render them void and unenforceable in Wisconsin. If you guys are on the webinar and have problems, there is a slide in here that talks about them. You can also message us and let us know if there's a problem. All right, so I'm going to start the presentation by talking about disposing of personal property after an eviction. The new law went into effect March 1st of 2015. While that's not exactly recent, it's about 1.5 years old, a lot of people are not aware of these changes. It is important to note that the old law will still apply to evictions filed prior to March 1st of 2015. So if you have a really old eviction out there, you may need to follow the old rules. And as I'll discuss later, the old law does apply still in a few instances. So I will talk about that now just briefly. Under the old law, a landlord had to arrange with a sheriff to move and store any personal property left at a rental after the eviction of a tenant. In most counties, this required that the landlord set up the eviction with a bonded mover, although some counties allowed you as a landlord to purchase your own bond of insurance. After an eviction, a landlord couldn't throw away any of the evicted tenant's property that's left. At the rental, only a sheriff could do that. Only a sheriff had the authority to determine whether something was trash to be thrown away or whether it needed to be stored. A sheriff also had to give an evicted tenant notice of the location of any stored property and the cost to retrieve it. And then finally, before you could dispose of any of that stored property, you had to provide 30 days notice to the evicted tenant. So that under the old law, obviously a sheriff had to be involved. That was pretty onerous on the landlord, and you had to give 30 days notice before you could throw away any stored personal property of a tenant. Under the new law, which impacts any evictions filed on or after March 1st of 2015, absent a written agreement between the landlord and the tenant to the contrary, a landlord can presume that any personal property left by an evicted tenant is abandoned. And then the landlord can dispose of abandoned personal property as it deems appropriate. There are a few limited exceptions to this rule that apply to prescription medication, medical equipment, and there are special rules for mobile homes or vehicles. This does make sense if you think about it. You don't want a landlord to be able to throw out prescription meds, medical equipment, and obviously if you're dealing with something really big like a vehicle or a mobile home, you have to follow some different rules. So if you have those instances, you cannot deem them abandoned and dispose of those. All right. Beyond notifying a sheriff that the landlord is removing abandoned property themselves, the sheriff does not need to be involved. And this is key here. The new law only applies if a landlord provides written notice in the lease that the landlord will not store any personal property left behind by the tenant. So this is where landlords, if you have a lease, you want to check your form lease to make sure that you include language that you will not store any personal property of a tenant that's left behind. Otherwise, if you don't include that provision, you have to follow the old law for personal property and evictions. So you would need to use a bonded mover. You just have to have the sheriff involved. Again, key takeaways, check your rental agreement, and remember that if you fail to have that provision that you won't store any personal property, you have to follow the old law. All right. There are also some changes recently to ATCP 134. As a quick refresher, Wisconsin Landlord-Tenant law comes from two sources. The first is Wisconsin Statutes Chapter 704. And the second is Wisconsin Administrative Code Chapter ATCP 134. So these were changes to the Administrative Code. They became effective November 1st of 2015. And this is very important. These changes are key for landlords to remember because violations of the Administrative Code can result in tenants recovering attorney's fees and double damages. So the first bunch of rule changes apply to security deposits. The first one, a landlord is no longer required to send a security deposit refund check to the tenant's last known address. You should note, however, that with this rule change, there was no legislative suggestion on where a landlord should deliver a security deposit return check. You just no longer have to send it to their last known address. In practice, as a landlord, you want to have your tenant specify where a security deposit return check should go, because you still need to return a security deposit to the tenant. Similarly, landlords are no longer required to write checks with all the tenant's name on them when they're returning a security deposit. Previously, if you had a lease with multiple tenants, you had to return a security deposit with a check, money order, that named all of the tenants on the check. You no longer have to do that. But like the rule change with the address, there was no suggestion on what you should do or who you should make a check out to. So in practice, you really should ask a tenant where they want a security deposit return check going and who the check should be made out to if there are multiple tenants. Best practice, if you don't ask those things of a tenant, you should still probably write the return check out to everybody so that you can't, you cover yourself from claims from a tenant for failing to return a security deposit. They also changed the timing for return of security deposits under the Administrative Code to line it up with what's required under the statutes. So the timing for a return of a security deposit is within 21 days of either the lease ending or a new tenant's lease beginning, or if you have an evicted tenant, when the premises is known to be vacated. Under the old Administrative Code rule, the 21-day clock started when the premises was surrendered. The next bunch of rule changes dealt with carpet cleaning. Under the old Administrative Code rule, a landlord could not withhold from a tenant's security deposit for routine carpet cleaning where there is no unusual damage from tenant abuse. Under the new version, you can include a lease provision that requires a tenant to pay for routine carpet cleaning. So you can include that in your lease. The catch is that it cannot be collected in advance. If you collect it in advance, it is treated as a security deposit because any prepayments in excess of 1 month's rent are treated as security deposits under the Administrative Code. So, You may not deduct the cost of routine carpet cleaning from a security deposit. That rule remains the same. Again, what does this mean? This seems to get us nowhere, right? You can include in your lease that the tenant is responsible for routine carpet cleaning. You just can't collect that fee in advance. If you do, it's treated as a security deposit, and you aren't allowed to deduct for routine carpet cleaning under a security deposit. So for landlords, you can include that provision. You'd have to, whenever you have carpet cleaning done at the premises, you would then send a bill to the tenant and have them pay that. All right. The next big one was Wisconsin Act 176 in 2015. This one became effective March 2nd of 2016. I will discuss some of the key changes that involve terminating a lease due to criminal activity, notices for non-rent breaches, limitations on local government authority, and trespassing on residential property, rental property. All right. The first one, criminal activity at a rental property. This applies to criminal activity occurring after March 2nd of 2016. A landlord can now terminate for criminal activity, including drug-related criminal activity. Note that criminal activity does not include the use or possession of drugs, which I will get into a little bit more in detail what this means. So, as a landlord, if there's criminal activity occurring at your rental property, you can terminate the lease by providing a 5-day non-curable notice to the tenant. This applies regardless of the lease term, covers criminal activity covered by the tenant, members of the tenant's household, or guests or invitees of the tenant or members of their household. The definition of drug-related, so as you can see, this doesn't include use or possession of drugs. Drugs are kind of treated specially under this criminal activity provision. It includes drug-related criminal activity, but that definition is manufacturing or distribution of a controlled substance. So you can terminate a lease for drug-related criminal activity if they are manufacturing or distributing, but not if they are merely using or possessing illegal drugs at your rental property. You should note if a tenant contests the termination of the tenancy, you cannot terminate over that. If they contest it, you have to prove by greater preponderance of the evidence, credible evidence, the criminal activity. So it goes to a court proceeding, and you cannot just terminate if a tenant contests. So what do you need in that 5-day non-curable notice to terminate a tenancy for criminal activity at the premises? First, you need a description of the criminal activity. Second, you need the date when the criminal activity occurred. You need to identify or describe the persons engaged in the criminal activity. You have to include notice that the tenant may seek assistance of legal counsel, volunteer legal clinic, or a tenant resource center. And then finally, you have to provide notice that the tenant may contest the allegations of criminal activity before a court commissioner or judge if eviction actions are filed. All right. The next change that came with Wisconsin Act 176 involved notices for non-rent breaches. Under Act 176, a landlord is now allowed to terminate a month-to-month tenancy by serving a tenant who's engaged in a non-rent breach with either a 5-day notice with a right to cure or with a 14-day notice that terminates the tenancy. The 14-day notice has no right to cure. Under the old law, landlords could only provide a 14-day notice terminating the tenancy. They didn't have the option of providing a curable notice. So in reality, landlords would sometimes overlook non-rent breaches in a lease rather than terminate the tenancy. Now they have an option to provide a curable notice. Under Act 176, a landlord can serve a month-to-month tenant with a notice advising them of the breach and giving them the right to cure. Again, it's a 5-day notice. And the Act also removes the requirement with the 14-day notice that a landlord serve it prior to the tenant remedying the breach. So if you want to terminate a tenancy for a non-rent breach, you can serve a 14-day notice, and it doesn't matter if the tenant remedies the breach before you serve the notice. So that's a big one for landlords. All right. The next bunch of changes that impacted leasing laws in Wisconsin under Act 176 were the limits that it placed on the local government's authority. It limited the powers of local governments in a couple of ways. The first is it prohibited the inspection of a rental property unless a criminal complaint has been made about the property or the inspection is a part of regularly scheduled inspections conducted in compliance with state and federal laws. Also, there can be no rental licensing ordinances unless the ordinances apply to all residential property owners, including owners of owner-occupied rental property. This one seemed to be aimed at cities who were requiring that landlords have leasing licenses before they could lease property. A couple of cities have these in effect, and they are still in effect even under this law because they do apply to owner-occupied property. In particular, the city of Wausau. So if you have rental property in the city of Wausau, you do need to obtain a rental licensing permit from the city before you can rent. But this provision of Act 176 was aimed at those type of requirements by municipalities to obtain some sort of licensing permit before you could rent property. The next limit limited rental inspection fees that are charged by local governments. Specifically, reinspection fees cannot be more than 2 times the initial reinspection fee. So local governments can charge an inspection fee for a rental property. They can charge a reinspection fee, but then on subsequent reinspections, that fee that they charge can't be more than double. This was the case where some municipalities would have an initial inspection fee. They would require every time the lease is turned over that you have another inspection, that you have the property re-inspected before a new tenant can be moved in. And that one would usually be at a slightly less cost, slightly discounted than the first inspection fee, but then they'd hit you with the 3rd inspection. So the first re-inspection, that fee would jump. It was aimed at landlords who have long patterns of leasing and getting a lot of re-inspection fees. So now we've capped those. They can't be more than twice the initial re-inspection fee. And finally, Act 176 prohibits local governments from imposing an occupancy or transfer of tenancy fee on a rental unit. All right, the final topic under changes from Act 176 involves trespassing at a rental property. Under Act 176, the definition of trespasser means a non-tenant who enters or remains in a residential rental property without the landlord or the tenant's consent. Act 176 makes it a Class A misdemeanor for anyone to intentionally enter and remain at another's dwelling without the consent, or if no one is lawfully upon the premises, to enter and remain without the owner's consent in circumstances tending to create or provoke a breach of the peace. That's what the new Act says. What else does it do? Act 176 requires that law enforcement agencies have a written policy in place for investigating trespassing complaints, and the policies have to include a requirement for removal of a person in a dwelling if the law enforcement officer has probable cause to arrest that person for trespassing. Sounds good, right? However, there are some rules if you have a trespasser who leaves behind personal property. If you have a trespasser who leaves behind personal property, the landlord has to hold that personal property for 7 days after the date of discovery. After 7 days, if it's unclaimed, you can presume that it is abandoned and dispose of it in any manner that you deem fit. However, if before the end of the 7 days the trespasser says, hey, wait, I want my property back, you have to restore it to them. Now, the trespassing rules are a little strange. This all seems great, right? We now have requirements that law enforcement have written policies to deal with trespassers. We have this new provision that defines trespassers at rental properties and deals with them. We specifically set out what you have to do if they have property that they leave behind. That's great. However, if you're a landlord, you want to be really cautious if you use this trespassing law. It's really hard to remove somebody for trespassing, especially if the person might be residing with the tenant. Rather than evicting, instead of using the trespassing law, you might want to consider evicting the tenant and their unauthorized guest, or you just need to make sure that you are really careful about who a trespasser is. The problem with this is we don't have any case law on how a court would handle some situations. For example, what if a tenant allows their significant other to move in with them? And everything's great, but they don't tell the landlord. So they have an unauthorized person living at the rental property. Things are great until they have a really big fight, and say it's the girlfriend. The girlfriend is the tenant under the lease. The girlfriend calls the landlord and says, hey, this guy is here. I don't want him here. He's trespassing. Kick him out. The landlord goes, okay, there's a law about that. He calls the cops, says this person's trespassing, and has them removed. The boyfriend had been living there. He left stuff behind. The girlfriend threw it all out on the front lawn, got it out of the rental property. The landlord did what he was supposed to, scooped it up, stored it for 7 days, and then threw it out because the boyfriend didn't claim it. But after 2 weeks, the girlfriend and the boyfriend get back together, and now the girlfriend's pretty mad that the landlord, A, called the cops and had her boyfriend kicked out, and then B, they're really mad because the landlord threw away all the stuff. So the landlord didn't do anything wrong under the law, but you could still be facing a legal argument here with the girlfriend about the trespasser. Was the boyfriend really trespassing? It seems so, right? But you'd have a factual battle as a landlord. One thing that you might, if you had had in the lease that they couldn't have any other people living with them at the premises, if that was in your lease as a landlord, you might have wanted to go the eviction route. Remember, you can serve for non-rent breaches. You could have served a 14-day notice to terminate. You could have just gotten rid of them. These are things that we don't know the answers to with this trespassing law. We don't know what a court would do. We don't know how they would rule. We can guess. We would think that in the hypothetical that I gave you, the landlord was in the right, he seemed to be a trespasser, the landlord followed the rule about property, but we just don't know. So you want to be really careful if you use this trespassing law to kick somebody out of a rental property. All right, now that I've scared you, I'm going to scare you a little bit more, because the next topic are the 10 deadly sins of residential leases. These are things you absolutely, absolutely do not want in your leases. I see these commonly when a landlord either has a really old form lease that they haven't had an attorney look at in years, or where they drafted one themselves, maybe getting it off the internet. I see that a lot with a landlord who pulled a form lease off of the internet, didn't bother to check what state it was in, and it wasn't done by anyone living in Wisconsin. The other thing that you'll see, some of these provisions that aren't allowed in residential leases are allowed in commercial leases. So sometimes we'll run into that too, where we have a client who has a couple of rental properties, residential rental properties, and then they also do commercial leasing. You can't necessarily use a commercial lease in a residential setting for reasons that I'll go through now. The first deadly sin of a residential lease: you cannot have any provision that allows a landlord to do any of the following things because a tenant contacts law enforcement or a health or safety services organization. So nothing in your lease can say that a landlord can increase rent, decrease services, bring an action for possession of the premises, i.e. eviction, or refuse to renew a rental agreement. You can't include any of those provisions in a lease, and you can't threaten to take any of those actions if a tenant reaches out to law enforcement or health or safety services. That one seems pretty self-explanatory, right? A landlord cannot retaliate against tenant contacts authorities about issues at the property. That's the first one. That's a big no-no. We don't usually see violations of this. Usually landlords know they can't threaten to retaliate in a lease. The second deadly sin is anything that authorizes the eviction of a tenant from a property other than by judicial eviction under Wisconsin statutes. In practice, this means that if a tenant refuses to vacate at the end of a lease or after they commit a breach and you've served them with notice to terminate the tenancy, the landlord is not able to engage in self-help in Wisconsin. So residential landlords cannot do things like changing the locks. You can't remove the front door of a residential rental premises. You can't turn off the heat or electricity. You can't remove the tenant's belongings. Those are all things that would be self-help, and you can't do that in Wisconsin. The only way to legally remove a holdover tenant is by following judicial eviction proceedings and going through that way. You can't have anything in your lease that says that you can evict a tenant any other way. The third big no-no in residential leases is anything that provides for acceleration of rent if the tenant defaults or breaches the rental agreement. This is sometimes included in commercial leases. A commercial lease will commonly include an acceleration of rent provision, but you can't include that in a residential lease. So if a residential tenant breaches their lease, you can't say as a landlord, hey, I'm immediately making you pay all of the rent that's due for the remainder of the lease term. That's what we mean by acceleration of rent. Can't do that under a residential lease. The fourth deadly sin is anything that requires the tenant to pay the landlord's attorney's fees or costs that are incurred under a lease dispute. Again, this type of clause is often in commercial leases. Often you will have something that says that the prevailing party is entitled to attorney's fees. That is not allowed in residential leases. A landlord who takes a tenant to court and wins still has to pay their own attorney's fees and costs. The fifth deadly sin in residential leases is anything that authorizes the landlord or a landlord agent to confess judgment against a tenant in any lease dispute. What does this mean? So a lease is prohibited from having a clause that says that a tenant authorizes the landlord to automatically take a judgment against the tenant and that the tenant has no right to defend against it. You can't do that in a residential lease. The sixth no-no for residential leases: any provision that relieves a landlord from liability for property damages, personal injuries caused by the landlord's negligent acts or omission. If a landlord causes damage or injury to a tenant, the landlord is responsible for it. You can't remove your liability by putting in a provision in your lease that a tenant waives that responsibility. The seventh is anything in a lease that imposes liability on a tenant for injuries or damages clearly beyond tenant's control, or any damages that's caused by a natural disaster or by persons other than the tenant or the tenant's guests. So a landlord can't have a provision in a lease that says that the tenant's responsible for someone else's negligence if the tenant has no control over that person. And by control, we mean like children. So under the law, a tenant would have control over their child. So if this isn't, you can have that in a lease, you can't have it where it's just anybody in the universe that they're indemnifying you for. And you also can't hold a tenant responsible for injuries or damages resulting from what we call an act of God, natural disasters, that you cannot make a tenant responsible for under a lease. Right. The 8th, can't have anything in your lease that would waive the statutory or legal obligation of a landlord to deliver the unit in a fit or habitable condition or to maintain the unit during the tenancy. A landlord in Wisconsin has to provide a tenant with an apartment or house or other rental unit that's livable and safe. And you have to maintain the rental unit for the duration of the lease term. That seems pretty obvious. All right, almost done. The 9th provision that's prohibited in Wisconsin leases would be anything that allows a landlord to terminate the tenancy if the tenancy based solely on the commission of a crime in or on the rental property if the tenant or someone who lawfully resides with the tenant is the victim of that crime. So this kind of overlaps with what we talked about earlier, where you can remove a tenant for criminal activity. However, you can't do that if the tenant is the victim of the crime. Yep.
What if it's a tenant that commits a crime against another tenant? Can you evict both of them or just the aggressor?
You could only evict the aggressor. You could not evict the victim of the crime. Right. And the last provision that's prohibited is anything that allows the landlord to terminate a tenancy for a crime committed in relation to rental property, and the rental agreement does not include the notice of domestic violence provisions that's required under Wisconsin statute. So leases should contain, a good residential lease will contain something like tenant shall not engage in or allow others to engage in criminal activity on the property. You want something like that in your lease. However, if you include something like that, you want to make sure that your lease includes the required domestic violence language. That's in Wisconsin statutes 704.14. You have to include that language verbatim in your lease. You cannot summarize it. You cannot you need to cut and paste it exactly from the statute into your lease to make sure that you can terminate for criminal activity. If you fail to include that language, then your rental agreement would be void if you include something like tenant shall not allow others to engage in criminal activity at the rental property. So, yep.
What is the exact language you don't know for?
I'd have to look up the statute because I cut and paste from the statute into any residential lease that I do. It notifies a tenant that they have rights if they're a victim of domestic violence, that they can, it notifies them that they have help, that they can go to the authorities, that you cannot terminate a lease if they're a victim of a crime. It goes through that. It refers them. It's not actually that helpful because it refers you to other state statutes, but it is pretty lengthy. It does have some subparts, and you do want to make sure that you capture all of that. I know that there's an A and a B and some other sub-provisions. So this is something that you want to go to the statute 704.14 and copy and paste into your lease exactly. For landlords, you want to make sure that your rental agreements, again, do not include any of the 10 things that I just talked about. Because if you do, it could render the entire lease void and unenforceable. Also, it can open you up to huge damages and attorney's fees in a lawsuit. Again, for violations of the statute or the administrative code, landlords can be liable for double damages and attorney's fees. All of these prohibitions that I talked about are in the administrative code ATCP 134. So you can go there if you ever forget, hey, what am I not allowed to put in my lease? You can check the administrative code. But because it's in the administrative code, you are liable for double damages and attorney's fees if you breach those provisions. Not to mention your lease would be void and unenforceable. So landlords, please, please, please check your leases. Make sure they don't say anything like this. The big ones that I most commonly see when I'm reviewing a residential lease are the ones for acceleration of rents. That one I've seen in a couple. But the biggest one is attorney's fees and costs. That's the one that sneaks into a lot of form leases, especially if landlords pull them from other states. Because a lot of other states would allow that kind of provision in their lease, but Wisconsin prohibits that in residential leases. Does anyone have questions on what I've covered?
Did you ask for the last month's rent with the security deposit? Is that last month's rent considered security deposit as well?
You asked for the last month's rent in a security deposit.
Last month in the lease.
Yep.
You asked for first month's rent, last month's rent, plus a security deposit. Is that illegal?
It's not illegal, but it would be treated as a security deposit. And there are very specific rules on what you can deduct for in a security deposit. You can have a security deposit that is greater than 1 month's rent, but everything is treated as a security deposit. So you have to follow all the security deposit rules. You can't withhold for anything that's unless that's above and beyond. You can withhold only for things above and beyond normal, ordinary wear and tear. So they have to be excessive damages that you're withholding. There are some provisions that you can include to withhold that are called non-standard rental provisions. That impacts a lot of things in security deposits, talking about what you can withhold for and what you can't. And then the big one is that anything that is treated as a security deposit, you have to return within 21 days. So you have the timing requirement too. The administrative code is pretty protective of anything that you're making a tenant put down in excess of rent. So those security deposit provisions are important. Any other questions? Do we have questions from? All right. Great. Questions from people online. The first one, for notices for non-rent violations, do weekends count in the number of days? Yes, weekends do count. Only for the 14-day notice. So the notice that you can serve that doesn't have a right to cure, the 14-day notice, weekends count. Except, there's always an exception, right? Except if the 14th day falls on a Sunday. You can't have your notice with the 14th day falling on a Sunday. Then day 14 would be considered the next Monday. The question also asks, when do you start counting? You start counting the 14 days or the 5 days from the day after you provide notice. So the day you give notice doesn't count as a day. Those are good questions, though. So the 5-day notice is different. 5-day notices, you don't count weekends. The 14-day notice, you do count weekends, but you can't have the last day be a Sunday. Another question, if there are multiple people on a lease and I'm returning a security deposit, what do I do? Okay. If you're a landlord with multiple tenants, the best thing to do is to bake into your form lease a provision about your security deposit that says landlord shall return the security deposit to insert tenant name, insert address. That's the best thing that you can do. You could also include it in your checkout form. As a landlord, you're required to give a tenant a check-in and a checkout form. And you could include in the checkout form something about where you should be sending the security deposit return and the name of the people that you want the security deposit return made out to. Those would be good things to have in your check-in forms. On that note, it's not one of the 10 deadly sins because failing to include it doesn't render your lease void and unenforceable. However, if you don't provide a check-in sheet to a tenant, you are liable for double damages and attorney's fees because you are required to include one. They do have a Form 1 in the administrative code if you need an example. So you make sure that you have a check-in and check-out sheet. The sample one online does not include a space for return of security deposit, but that is something that I'd recommend you include. All right. The third question. If I think a tenant is dealing drugs, can I give them a 5-day notice to terminate? Yes, you can. Probably. You want to make sure that you have enough to provide them with the required notice, which, as we discussed, you need a description of the criminal activity, you need the date that you think it occurred, you need the identity or description of the people who are supposedly engaged in that activity, and then you have to include the 2 notices. The notice that they can seek assistance of legal counsel or a legal clinic, and the notice that they can contest the allegation. Again, you want to be careful with the drug one. So if you think they're dealing drugs, yes, you can provide them with a 5-day notice to terminate, but you need to make sure that they're actually dealing drugs, not just using and possessing them, because that does not fall under drug-related criminal activity in the statute. Yes.
So basically, if you know that your tenant is using drugs and is in possession of illegal drugs, you can't do anything about it.
You cannot provide them the 5-day non-curable notice to terminate their tenancy.
You could call the cops on them, perhaps?
Call the cops on them, yes, because they are engaging in illegal activity. If you included in your lease the provision that tenants shall not engage in illegal activity, you could provide that would be a breach of their lease, and you could proceed that way. But if they're only using illegal drugs at the property, you can't give them that 5-day notice and terminate.
If you think that they possess drugs, are you obligated to do anything?
No, you're not. No. And remember that you still have all of the things, you still have to follow the rules. You can't, if you think they have drugs, you can't just enter their property for no reason. There are landlord limitations on when a landlord can enter the premises. You have to provide notice. You can't get around that just because you think they have drugs on the property. Anybody else have questions? Anybody on the webinar?
I just want to clarify what you said. The 5-day notice starts to run after they give the notice.
Yeah.
It doesn't depend upon what type of notice.
It does. So it does depend on how you give notice under the statute. But when you start counting, so if you provide notice by mail, it's a certain number of days after you provide notice by mail. So you'd start counting the day after it's deemed that given. So that is a good clarification, yes. Not necessarily the next day after you give notice. It's the day after you're deemed to have given notice under the statute. If you personally serve notice, then it would be the next day. All right. If you guys have any questions, my contact information was provided in the handout. So let me know if you have questions on anything that I've covered.